So yeah, good evening from Antwerp, and very good day somewhere in the U.S. I think New York and California we're talking about. ICONAS created an annual book prize to recognize outstanding books, books in the field of public law. And at this year's conference in Madrid, Rabiata Kandi's book, Entangled Domains, Empire, Law, and Religion in Northern Nigeria, deserved a special mention at the conference. So it was a runner-up book. So to that end, the committee invited her to present her book with us to wider audience. And let me tell you a few words about Rabiat. Rabiat is associate professor at the University of Maryland, and she works in the fields of legal history, law and religion, but also constitutional and comparative constitutional law, Islamic law, international law, and post-colonial African law and society. Welcome, Rabiat, but also welcome, Mark. We know Mark very well because we presented his book. He presented his book with us, his book Sharia Inshallah, that was awarded many times on different occasions. So given his expertise in the field, we also invited Mark to discuss Rabiat's book with us. Even though we know Mark, let me tell you that Mark is a professor of politics and a chair of politics and director of legal studies at the UC Santa Cruz. And Mark studies how people build and destroy nations, why and how they create legal systems, and why religion actually matters in politics. My name is Maya Sahajic. I'm a co-chair of the Committee of New Directions in Scholarship, and I also welcome Mark to this discussion. I'll start with the first question, which is directed to Rabiat about her book, about the main claims that are advanced in the book. So what are the main claims, Rabiat? Can you present it to us?
Right, absolutely. Thank you again, Maya, for the really kind introduction. To join this. It's a real honor to be doing this, and of course to be having this discussion with both you and Mark, whose work I've admired for many, many years. Real honor again. Thank you, Mark. So the book really confronts a paradox according to which the British colonial state in northern Nigeria claimed that it was separate from religion, right? And that's traditionally understood as a thrust of a constitutional idea of secularism. But at the same time, the state was also in many ways entangled, deeply entangled, in fact, with religion. And so I, in the book, try to understand how these two things, right, could simultaneously coexist in British colonial Nigeria. How could a colonial state that was governing the territory through what remained of the colonial caliphate, and so obviously entangled religion in that sense, while also at the same time insisting that it was distinct from religion, right? And so, for instance, this was a state that was described by Christian missionaries as one of the worst places in the world to be a missionary, and the state would respond by saying, yes, that's in fact our posture to Christian missionary activity because we are distinct from religion. So how could these two things coexist? How could a state that was separate from religion also be deeply entangled with it? And so entangled domains confront that question by thinking about the conditions under which these two dimensions, right, of governance could coexist. I think about the contestations that they set in motion between colonial actors, between colonial officials, between Muslim elite, Christian officials, and also consider the legacies of those struggles for post-colonial Nigeria, a state that is, of course, now home to Africa's largest Muslim population, and is also the most populous Black nation in the world.
I hear you I heard you saying that the book is about religion, about colonialism, coexistence, legacies, interaction between all of these terms, concepts, and so on. Is it related to why you decided to write the book, or are there reasons apart from this why you actually decided to write the book?
Right, absolutely. So, I mean, I first became really interested in the topic, um, during my earlier years in college when Nigeria was, undergoing what was regarded as a constitutional crisis, which really centered about the place of the Sharia and the state's constitutional order, right? So, could we have, the Sharia in public law, right? So this was a time when, certain states in northern Nigeria had actually legislated, criminal codes, right, criminal law based on the Sharia. So the question was, is that actually possible, right? Is Nigeria secular? What does it mean for Nigeria to be secular? And what was really striking to me was that the two sides to the debate at the time actually understood themselves to be grounding their claims in colonial history, right? So both sides of the debate, on the one hand, those who were arguing that in fact, Nigeria ought to have, Islamic law as part of public law, and that was in fact not at odds with, the state, the form of constitutionalism that Nigeria embraces, were arguing that in fact, that move was actually a response to what they saw as a colonial legacy that had disenfranchised Muslims, right? So colonialism disenfranchised Muslims. This is the post-colonial moment in which we're now trying to transcend that disempowerment. But on the other hand, those who were arguing against the proposal to actually have Islamic law as part of public law were actually putting forth the idea that in fact, colonialism actually, that colonialism was a form of Muslim sub-imperialism, as they argued, and that in fact colonialism had disenfranchised other faiths and primarily Christianity, and that the post-colonial resistance, as they put it, to the Sharia project was actually a resistance to the legacy of colonialism. So I became really interested in, well, what exactly does colonial history have to do with all of this? But at the same time as that, as I was grappling with those questions, I also, many years later, right? And this, of course, the book is a product of a doctoral dissertation that then grew, right? That was a product of the angst that I was feeling, right, while I was processing those debates. So as I was thinking about the Nigerian struggles, I was also just really struck by the fact that, right, it's very commonplace, of course, for states to claim their separation from or certain degrees of distance from religion, which again we understand as a thrust of the idea of secularism. While religion, is tenacious, right? So for all predictions that religion would decline, and that liberalism would somehow overcome religion. Religion is still with us, right? It's everywhere, right? So what are the tensions, right? That these two things, right? The assertions of separation and the tenacity of religion. What sort of tensions actually arise from that? And so these were the broader questions that I was grappling with as I began to research the project and began to think about the past, began to look into colonial archival material to understand what colonial history actually meant, right, for the making of the Nigerian state, for the making of constitutional order in Nigeria. But also I wanted to think about what the history of colonial liberalism, colonial, secular governmentality, as I put it, colonial liberal modernity actually meant for the making of the state, right? And how might the lessons that I actually gleaned from the Nigerian experience help me to understand debates that are going on, right? Much, very far away from the Nigerian context.
When I hear you explain, why you decided to write the book, it is obvious that, your intended audience is obviously your colleagues who are interested in the same or similar topics. But I also somehow think or feel that this book is also directed maybe to the government officials, to religious leaders, to people in general. But I'm still interested to hear from you. Who is your intended audience, given, the motivation and inspiration and so on?
Right. So, as you've noted, I intend, the book to be in conversation, but with scholars who are thinking about questions of the interplay of law and religion, with scholars who are interested in thinking about constitutional history, right, and specifically the making of the state, right, the foundations of the state's constitutional order. I'm interested in scholars who, I want to be in conversation with scholars who are very much interested in colonial legal histories, right? Again, the history of colonialism, the forms of legality that emerged from colonialism. But of course, I also want this to be a book that is read, by the broader public, right? So beyond scholarly audiences, right? Would be great, right? If Nigerians could actually read the story, right? So the non, scholar, right? The average person, could actually read the story. And so I do intend that it be a book, that actually speaks to scholars across a broad range of audiences, right? Beyond, the area specialists, beyond the scholars of African law and history, to think about comparative legal scholars, global legal historians, but also, again, the broader public.
I hear that you're also very excited when you talk about your book. But let me also turn to Mark, because that's also somehow inspiring for me to hear when you talk about your book. But I also want to hear from Mark. What do you find interesting, illuminating, inspiring about Rabiat's book?
Maya, thanks for having me here, and Rabia, thanks for writing just a really marvelous, marvelous book on the legal history of northern Nigeria. I like this book for a lot of reasons. I like this book for a lot of reasons. The first reason is that it takes legal history and law and society both seriously and brings them together. Legal historians often think that studying law and or religion in the colonial enterprise is maybe the realm of legal history. Law and society scholars maybe think that studying law and religion in the post-colonial enterprise is the realm of law and society scholars. And what Rabiat does nicely in this book, in Entangled Domains, is look at both the colonial enterprise and the interactions of law and religion in the making of colonialism, in addition to the pre-colonial caliphates in northern Nigeria, as well as the post-colonial enterprise. What do these colonial legacies leave? These colonial legacies that framed religion as an important part of the state's governmentality, to use the words that Foucault used and that Akande, that Rabiat uses in her book as well, that religion frames this governmentality in the post-colonial period is really kind of a law and society project. And what this book does is, in thinking about both the colonial and the post-colonial, it brings together legal history and law and society in a really satisfactory way for me as a reader. So I think the book appeals both to legal historians because of the depth of the archival research that was done, but also to law and society scholars who are thinking more broadly about the relationship between religion, politics, and the state in northern Nigeria, or more broadly. So that's the first thing I like about this book, is the way it brings together legal history and law and society. The second thing I like about this book, or another thing I like about this book, is the way it gives attention to law and religion in state governance. A lot of sociologists of religion care about the questions of how law shapes religion or ideas of religious liberty in state governance. A lot of legal scholars care about how constitutional court cases shape how people think about religion or law. And what this book does is bring, again, both of these dimensions together. Law from the vantage point of law, religion from the vantage point of religion, but also law and religion together as this kind of, if I could describe it as a kind of like double helix, in the sense of a DNA strand, where law and religion are kind of circulating together, and the state needs both of them in order to operate and rule. And Rabiat tells us in great technical detail how the state needs, the colonial state needs law to govern, of course, but also needs religion to govern, and also needs this combination of law and religion in order to govern a population that is Muslim, a population that is Christian, and a population that is neither of these. Some colonial administrators, in Rabia's terminology, labeled them as pagan. Uh, so that's the second thing I like about the book is the way it takes law and religion seriously. The third thing is that and there's more, I'll just highlight these three. So the first was the way the book takes law and society and legal history seriously. The second is the way it takes law and religion seriously as categories that are complementary and that need one another. And the third thing is the way that the case study in this book, the case study of Northern Nigeria, offers a lot to scholars who are not only interested in Nigerian politics, colonial and post-colonial politics, but also to scholars who are interested in colonial and post-colonial politics in many other British colonial and post-colonial societies. How to make the question I think that ultimately drives this book is how do people think about what makes a good society? What religious ideals go into making that good society? What legal principles go into making that good society? To a lot of scholars, drawing from John Rawls, the political philosopher, and others, what goes into making the good society is separating, disentangling law and religion, or the state from religion, such that law becomes part of the state, religion becomes this separate private enterprise, which, as Rabiat argues in the book, is a very Protestant Christian way of seeing the world. What this book does is show how these different domains, to use the book's title, these different domains become entangled with one another in the development of how people think about what a good society is. How law and religion and politics ultimately get entangled, and the process of disentangling them is itself a form of politics, not only in northern Nigeria or in the creation of the post-colonial Nigerian state, but also in many places. And so the book offers takeaways and lessons for all of us who are interested, not only in Nigerian politics, but also in politics more broadly, including in states that call themselves secular, such as the United States.
Thank you, Mark. Well, you were talking especially about the first thing that you actually like about the book. You mentioned how Rabiat combined the legal history and the law and society and so on. And it somehow reminded me that it's part of the methodology, maybe. So I cannot help not asking Rabiat, what was your methodology in this book? What was your approach, methodological approach in this book?
Right. Thanks, Maya. It was really, really, really great to hear Mark make those remarks about how the book tries to bring together the fields of law and society and legal history. So it's a work that very much relies on historical methodology, but it's one that does so by actually tracing the history of ideas about religion and religion governance through law, ideas about the making of the state, by thinking about law in society, right? And so this is precisely how it actually brings both fields together. And so it's not, in fact, it's not, just about law and society. It's archival materials, in the UK and in Nigeria, archives in, Nigerian National Archives in Kaduna. I look, at archives at the National, Archives of the UK, in Kew in Richmond. I look at it, a lot of missionary archives, which are pretty scattered all over the place, from, Birmingham to, to London to Edinburgh. And really, what I try to do by looking at those archival material is to think about the history of the ideas that I'm trying to trace, the history of the struggles, by looking not merely at the, the typical legal materials that legal historians might ordinarily look at, meaning, judicial decisions, records of court cases, constitutional, reports of constitutional conferences. But I also look at things like correspondence, right? Letters, right? What were the sort of arguments that were made in private, right? Do they actually map onto what I see unfolding in public? I look at newspapers, right? So much of the public discourse that I try to trace were actually not only unfolding in sort of the paradigmatic public terrains of, the court, or again, constitutional conferences, or, commissions created by the state. Much of it was also unfolding, in fact, in newspapers, right? Ideas about the law, ideas about the proper relationship between law and religion, right? And so I map these by looking at both these, classical, pragmatic, legal materials, but also by looking at materials that we might ordinarily not think of as being sources where we might actually glean ideas about the law, legal discourse, or legal debates, but actually are really rich, certainly in the colonial context, in thinking about these debates and arguments and how they travel across time.
And Rabiat, how is that different from your existing scholarship? How does this book fit within your existing scholarship in terms of, methodology approach, not just methodology and approach, but in terms of content and so on?
Right. So, much of my work grapples with the interplay of law and religion in the colonial context. And I think about colonialism not merely, as a phenomenon, as a time period, not merely as sort of in terms of a static time frame that begins in 1903 in Northern Nigeria and ends in 1960. To understand colonialism, I argue that, in fact, we have to understand the before, right? So you cannot trace legal transformations that unfold during colonialism without understanding what was the before, right? What was the pre-colonial, right? What does it mean to speak of the pre-colonial? What forms of legal institutions, legal debates did the colonial state encounter, right, when colonial governance began? And so I think about colonialism both in terms of what we might call the pre-colonial, but I also think about the legacies of colonialism. And so my work in thinking about the interplay of law and religion actually then, thinks about both the pre-colonial, the colonial, but also, the post-colonial. And as I do so, I want to underscore, right, which was also a point that I think Mark made a reference to, that in fact, part of what I do in Entangled Domains, and that I do more of, that I've begun to actually think more of in more explicit terms in recently, is actually to theorize religion as to theorize and to historicize, right? The emergence of religion. What do I mean by that? So I have begun, for instance, to think more recently about what I think of as the mutual co-constitution of race and religion, right? And the forms of authoring that was foundational to colonialism, right? What were the forms of legal discourses that justify colonialism? As well, you actually cannot understand without understanding what the role of othering played in that. And to do so, we have to understand that it was not just a form of racial othering, as typical account would normally put forth, or just religious, but it was actually both. And so my work actually grapples with that. So thinks about law and religion and the interplay in the colonial context, but does so right in a way that thinks about what the pre-colonial and post-colonial might actually mean for how we understand colonialism, while also theorizing and historicizing the religion as a category of scholarly inquiry.
Thank you, Rabiat. Maybe similar question, but from a different angle for Mark, about the line of scholarship upon which this book actually build upon. How does it differ from the existing accounts in this field, in this area?
Right.
Thank you.
Oh,
Rabia, sorry, I didn't know if that
no,
question
no,
was for
no,
me
you
or
go,
for you,
That was
please.
for
Rabia.
Mark.
No, you go, Mark.
Yeah, so I appreciate this. So the question about um, how does the book build upon but also differ from existing accounts of law and religion? I mean, I see this book directly in line with, and Rabiat cites to Talal Asad's 2003 book, Formation of the Secular, and a number of Talal Asad's students who've come after him, Sabah Mahmoud, Hussein Ali Agrama, and others who've thought about these kinds of questions in other contexts, specifically the Egyptian context. I like that Rabiat adds the context of northern Nigeria. I think this is a book that if you read it only for its contribution to understanding the development of the Nigerian state, this would be an outstanding book. What I like about this book is it builds out from there, making a contribution more broadly to theorizing the relationship between law and religion, using the case of northern Nigeria as a case that all of us should be aware of, precisely because it helps us see the ways that the project, which is a very colonial project, according to Entangled Domains, according to this book, it's a very colonial project of separating or disentangling law or the state from religion, on the other hand. This secularizing project um, is actually a deeply political one that relies a lot on religion. So religion becomes deeply entangled in the very formation of the state that itself is telling everyone that it is non-religious. And so Rabiat is trying to get us to see that the way that the state at once paradoxically calls itself non-religious, but relies entirely on religion to do that, I think is an outstanding contribution to how we think about the relationship between law, religion, and politics, and specifically secularism. The other thing I want to say is what was mentioned earlier around the chronology. The fact that this book thinks about these tough and paradoxical questions across time, from the pre-colonial caliphate period to the transformations during the colonial period, to the 1960 independence, to the 1977 constitutional moment or constitutional crisis, to court cases that came after 1977. This is a long chronological expanse through which to test empirically the arguments that Akande is making around this relationship between law, religion, and politics, that the state at once calls itself non-religious, yet requires religion in its very fabric, in its very fabric of its secular nature. Religion is embedded and entangled in the very it weaves religion, like the law, weaves the very fabric of the creation of the state. So I think that's how I see the book sort of contributing to this line of scholarship on secularism, but also departing from it in its kind of grand chronological sweep, and introducing a lot of readers. I'll be honest, introducing a lot of Western readers who don't traditionally think about West Africa. Western readers and the case specifically of northern Nigeria as an important site to study these questions of law and religion and politics. And Akande is staking her claim that if we're going to understand colonialism and what it does to law, how it shapes law, what it does to religion, what it does to Muslims in a certain society who are elevated at some level. And this is the kind of received stories that Rabiat tells us in the book, that Muslim minorities, in many ways through colonial rule, are elevated to indigenous faiths. But also there's a flip side to that story, is in the process of quote unquote being elevated, these groups are also being marginalized and co-opted and reshaped. And a new kind of colonial Islam is taking shape, which then impacts how post-colonial Muslims in northern Nigeria even understand Islam in the present day. So all of that, I think, makes this a rich and meaningful contribution, both building from but departing out of existing accounts.
Well, I hear both of you talking about different aspects of the book and why the book is very, let's say, novel, apart from, filling the gaps in the scholarship, and especially when you talk about the connection between law and religion, but also what Mark said, the development of Nigerian state. But you also mentioned chronology. You also mentioned a great technical detail that Rabiat used in her book. So I wonder, Rabiat, what was the most challenging part in your research, in your writing process that you experienced, given the complexity of the topic and also the theme that you had to address?
Right, thank you, Maya, and thanks again, Mark, for this really great. It's always wonderful to hear one's walk through the lips, the eyes of others. It's a real pleasure to hear you make those comments. I mean, there were theoretical challenges, methodological challenges in writing this work. So Mark made reference to the contribution that the book tries to make to the what is now described as the Assadian tradition, right, in law and religion and theorizing secularism. And in fact, when I began to write the dissertation, and of course, when I began to think about the book project, right, as a post-dissertation project, I was very much influenced, and I continue to be very much influenced by the Assadian seminal argument that challenges the so-called neutrality of secularism, that asks us to historicize, right, and to theorize, the making of the categories of the sacred and the secular, right, and that in fact the secular is not about drawing a line between the law and religion. In fact, religion itself is already constituted, right, by the law. So the law is both drawing the line, and of course also at the same time constructing both the sacred and the secular. And so, as I began to walk, through the archival material, and I began to think about my story, I could see that argument, but it was challenging to actually think about what not only the construction of the sacred and the secular and the drawing of the line between them, which I could read through the Assadian, tradition, Sabah Mahmoud could tell me, but I began to say that actually in the context of the struggles that I was trying to understand, to write about, that these categories were not only constituted, they were also being reconstituted, right? And I think it was actually at that moment, so it was both incredibly challenging theoretically, but it was also for me the moment of the breakthrough, right, in the book, right? The moment where I actually saw how the storyboard was within this tradition, was responding to this tradition, but also was moving further, right? In that I could show from the stories that it's not only about the construction of these categories, it's not only about the making of hierarchy, it's also about their reconstitution. And that's precisely why the hierarchies are not stable, right? So the flipping of the hierarchy happens, I would say in colonial context, certainly in another Nigerian story, it happens much more quickly than it might happen in another context because of the relations of power that colonialism set in motion. But understanding that the politics of secularism is not only about the constitution of the categories of the sacred and the secular, or of law and religion, but also about their reconstitution, helps us to actually understand the relations of power that colonialism sets in motion, right? And the legacies that it actually, bequeaths to the post-colonial state. And so that was a theoretical challenge that then turned out to really pay off, right, once I actually moved. But so then, in terms of methodology, right, so I already made reference to the fact that, uncovering, the archival material that I had to, go through meant working in many, many archives. So that was really challenging, right? Because, indeed, the ideal is always to just have all of your archives in, one place, so like really tidy. Some scholars are really fortunate to be working on archives that have now been digitized, and so they can just essentially work, right, on their computer. So this was not at all a project in which I could do that. I had to, travel to many different places. I also had to grapple with the challenge of the state of the archival material in Nigeria. And so, you know, trying to access materials that have not always been preserved in in the best of forms. Much of it is just a product of resource, just shortage of resources. That was also challenging. So methodological challenges that arose from just the complexity of accessing the archival material, but also the theoretical challenges that I made reference to earlier were some of the most notable that I would mention.
But I'm sure, apart from all of these, theoretical, methodological challenges that you faced, I'm sure that there were also some rewarding parts of your research. So maybe you want to share those as well.
Right. So this would be tied to my previous comment, right? So that one always finds, right, the reward, right, within the challenge and stuff. Like if only one actually leans into the challenge. But just something very basic. It was wonderful to just complete writing the book. It was an 11-year project. And so it was just great to to complete it. It's just, on a, on a sort of, on a personal note, as I was writing the book as an African scholar, as a Black, Muslim woman, I really wanted to think about how this story might show how Africa and certainly Africa, predominantly Muslim societies, um, are also sites for the production of knowledge, right? Um, uh, you know, Africa is not merely a place where we get the data and then we get theory from elsewhere, and it's also a place where we can produce theory. What theory is being produced every day, right? As the Comoros, wrote in their Theory from the South book, published, I think about a decade ago, right? So theory is being produced and so, I really wanted this to be a book that would generate insights, right, about the workings of secularism, about law's interplay with religion, about the constitutional foundations, of the modern state and what liberal imperialism had to do with it, that would not only be relevant to Nigeria, which was very important to me, right? That it be relevant for Nigeria, but also that it would also produce insights that would be more broadly relevant in many different places.
Maybe a question for Mark. When you say, the rewarding part of the process was actually to complete the book, and then you also said, this is what I would want this book to be. But maybe it's better to ask Mark. You already mentioned, I think, bits and pieces, or you scratched the surface a little bit when you gave the answer to my previous question to you. But what do you think? What will be the book's impact in this field, or what is already this book's impact in the field?
I think there are three maybe arguments in the book that I think have a kind of field-defining impacts, and let me see if I can go through them. The first is this distinction that Rabiat was speaking about, and the book really it cuts to the heart of this distinction between the sacred and the secular through, as Rabiat said, the constitution of these ideas, but also, as Rabiat made clear in our interview today, the reconstitution of these ideas, that the sacred and secular are not necessarily at odds with one another. I think that's a huge and important finding, that these two things that are seemingly opposite are not necessarily at odds, but they are placed at odds with one another through struggles around hierarchy and power. In other words, our politics is what places sacred and secular as separate domains. And I think that's the first kind of finding that I think has a substantial impact in how we think about the relationship between law, religion, and the state. That these two ideas are not a priori separate from one another, but they are made to be separate through our legal and constitutional and political struggles, through the very act of nation building. whether it's colonial nation building or post-colonial, post-independence nation building. So that's the first kind of impact I see around sacred and secular not necessarily being at odds in the way that people might traditionally expect. The second one is around secularism itself and what it means. And Rabiat makes this argument very clearly in the book that the things that we all care about, the Rawlsian notions of impartiality, tolerance, neutrality, these things that matter in the creation of democracy, that laws are neutral and impartial, that societies practice toleration for difference. That these ideas came with secularism. These ideas were actually part of the process of separating or distinguishing law from religion or the state from religion. And so by promoting ideas of impartiality or neutrality or tolerance, colonial administrators were actually imparting broader ideas of what they saw as secularism or separating the state from religion. The next thing I want to say in terms of the book's impact is ultimately, and this gets to where Rabiat is going with her ongoing research on the interactions of race and religion, is this is really a book about the governance of difference. This is really a book about the governance of difference. It's about who has the right to govern difference. Who does it even? Who has the right to do it? What happens when they take on those roles for themselves? Be they missionaries, colonial administrators, even human rights activists, lawyers, Nigerian lawyers, Muslim activists who are fighting for a Sharia court of appeal, as Rabiat outlines in the later chapters of the book, Christian activists who are fighting for an independence of Nigeria that relegates Muslims to a kind of secondary status, post-colonial Muslims who then use those same arguments that were used against them to promote Muslim religious liberty in a post-colonial Nigerian context. All of these, I think, are great impacts of the book in terms of the impacts for contemporary Nigerian politics as well. So it's a book that's rooted deeply in a pre-colonial and colonial history, but says a lot about what this means for contemporary Nigerian politics.
Amazing. That is just amazing. I find it amazing. But you also mentioned ongoing research that Rabiat is already doing. So I think that's a great catchphrase, or I'm not sure how to even call it, but also something to finish this conversation with. Maybe just to ask at the very end, Rabiat, what are you working on right now? So what is next for you after this book? After, as you said, it was an 11-year project. So what's next?
Thanks. So I'm working on a number of projects now. I'm going to talk about the two major ones. The first is it's a collaborative project in which I'm working with a number of scholars across different disciplines, anthropologists, historians, political scientists, religious studies scholars, to historicize and to theorize ideas about the international in pre-colonial Africa, so legal ideas specifically. So what forms of ideas about international law existed in pre-colonial Africa? What might that offer for how we think about the universality of international law as we currently know it, right? But of course, as we think about that question, we are asking, are these international legal ideas? What are the stakes for naming it as law, as international? And so that's one that we're actually now in its final stages, and really excited for the book to be released soon. And the second project, which is a solo project, is one in which I'm taking seriously those years in the 60s, in the early 60s, when Malcolm X travels across Africa and encounters African nationalists, some of them Muslim, some of them not different religious faith, but all these folks are really concerned, right, about Pan-Africanism, right, about the question of the emancipation of Black peoples across the world. And so I am following him, as he encounters these different scholars as a way to try to understand ideas of emancipation, right, that we're putting forth, but ideas about, reordering the world, ideas about how to counter hegemony, ideas that were in many ways a critique of the making of the nation state, right, as a product of colonialism, at the time. And in fact, those those travels have usually been presented in books that have, written, that have started to chronicle the life of Malcolm X, and there are many of them. But those travels have usually been presented as a footnote, right, as though it was just sort of, an afterthought. But I want to really take them seriously as a way to really think about this idea of alternatives that as I read them, were really about how to embrace difference, right? How to actually imagine a world, how to imagine a political order in which people would actually belong, right? And so that's what I'm doing right now. I'm really excited to complete those sets of projects.
Thank you, Rabiat. Thank you, Mark. Also, this was a lovely conversation, but also very illuminating. So thank you both for agreeing actually to do this. I'm very happy we actually did it. And I'm looking forward, Rabiat, to your future work on both of these projects that you just presented. Thank you. Thank you so much.
Thank you so much, Maya. I really appreciate it.
Thank you, Rabiat and Maya.
Thank you, Mark.